Good morning, welcome back. This is Daybreak and thank you for staying with us. The hashtag on X is Citizen Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir. A defining morning starting today on Wednesday for the Deputy President Rigathi Gachagua, with the Senate set to proceed with his second leg of impeachment following the ruling yesterday by Justice Chacha Mwita, who declined to issue the conservatory order sought by his legal team to stop the Senate from proceeding with the impeachment. Today with me in studio are the 49th and the 50th presidents of the Law Society of Kenya. In that respect, Nelson Harvey and Eric Dauri. Good morning. Councils, much appreciated for your time. Esther Mushiri is as well a lawyer who joins us this morning here on the broadcast. Good morning, Esther.
Good morning.
Thank you for your time. And Dr. Duncan Ojwang is as well a lawyer and teaches constitutional law. Good morning, Dr.
Good morning.
Much appreciated for your time, lady and gentlemen. A lot to chew here in the course of this broadcast. First, let's begin with your thoughts here. And I start with you, Dr. Ojwang, given what is set to transpire, the Senate and the last-ditch attempts yesterday by the DP's legal team, and a ruling set by a three-judge bench this morning at 8 a.m. set for delivery on the same. Chacha Mwita yesterday still declined to issue the much sought-after conservatory orders to stop the Senate. It seems that this impeachment has also brought to the fore constitutional thoughts that ideally had led to many interpretations as to the arms of government and the conduct of their businesses.
Yes, so you are right that the bench that will be listening or giving directions this morning at 8. Of course, you know, cynics say that if all these 24 cases were and effort were put in reaching out to senators, maybe we'll have convinced 24 senators. So there is, of course, a lot of frantic effort in the temples of justice, putting them in tension and requiring them to stop the process. But remember, the process had already begun. So whether they are comfortable stopping it, because Senate is seized of the matter, had already planned out the schedule, so they have already started prosecuting the matter. If I was honest, I would say lower your expectation if you think court could just efficiously intermeddle with such a clear constitutional process. I don't see it coming, but of course this is Kenya, and you could expect that court has some limited powers. To what extent will they see it fit to injunct such a process? I don't see it, and therefore a very low expectation. I'm more of waiting to see the real duel in the Senate, because I think now parties have firmed their position, have sized each other, and of course now there is the chance for cross-examination. And you know, in cross-examination now, up and close, there will be a lot of trying to show that this is inconsistent, this is not becoming of the character, this witness is a liar, and therefore there is a lot to look forward to. We have closed our classes. I've told my students, please look at the Senate trial and pick some tactics for your future use. Thank you.
Okay. And Council Harvey, I'll come to you because of your thoughts on the Constitution not contemplating judicial intervention on impeachment, a position you held, and the series of arguments that you have had with colleagues on your X platform. But first, Esther, coming to you, what do you make of this entire process, given the much sought-after conservatory orders by DP Gachagua's legal team to stop the second leg of his impeachment at the Senate?
I think the first thing that we must be alive to is the functionality of the principle of separation of powers and the need to specifically allow institutions, and which I really trust it, I have my trust in, to expedite and undertake their processes in ensuring that If it's the legislature, it's allowed to do its work. And then, of course, the judicial function here, the High Court has jurisdiction to undertake to hear any dispute that any dispute that will arise now from the processes. So in this case, one of the things that we must notice is that we are looking at a political process that requires a legal solution, and legal to mean the constitutional solution, and a process that now with the legal or constitutional solution, it requires that then we adopt the strict concurrence with the Constitution in as far as the entire process is concerned. Eventually, we are also seeing that the Senate now is undertaking a quasi-judicial function. And by extension, what that means is that they should restrict themselves to integrity and fairness, and of course abide by the principles set out under Article 10 to ensure that justice is seen to be served and justice is seen to be done. Yes.
Okay. And Council Harvey, coming to you, what's your thinking of as well the voluminous evidence that we had seen filed before the Senate and by the National Assembly, the lawyers, and as well the defense team of the Deputy President, given what's coming before the Senate today, which will sit as a quasi-judicial house before we debate on the post-trial at the Senate, and what you have, the grounds that you have also held regarding the contemplation that the court does not intervene at that process and all ends at the Senate politically?
Well, I'm no fan of the Deputy President, Rigathi Gachagua. Neither am I an admirer of Parliament, both the National Assembly and the Senate. And if you look at the Standard, page 12 today, Harry, the cartoonist, has depicted the picture quite elaborately. We have here one hyena in yellow who is on the dog, another hyena there as speaker, and several hyenas here.
As members.
Answer the question truthfully. Do you have more? Why do you have more sports
than the rest of us?
Than the rest of us? Indeed, this is the case. And I wouldn't blame Rigathi Gachagua for filing as many cases as possible. It is a realization on his part, it is my supposition, that this process will not end badly. But he is doing all these things for the record. And as I've said before, sometimes the savannah must burn for the grass to grow again. It is a test both for the Senate now as we go, because the Senate is supposed to investigate. It is supposed to sit as a court, and after investigating, to ascertain whether these charges have been substantiated. So the burden on the Senate is much higher than that of the National Assembly. The National Assembly's role was perfunctory. It was just a voting machine. In fact, it raises doubt why they are wasting all that time debating this issue, yet 291 of all of them had already signed. It was fait accompli. But for the Senate, this is the trial court where all of the 11 allegations must be interrogated on evidence, not just allegations and conjecture, and a conclusion made. And it's for that reason that we have maintained that position, that the intervention of the court is not permissible at this point in time. And we must speak guidedly as lawyers, because we've seen some of our colleagues there in Parliament and the executive taking very stringent positions that are not in conformity with what a lawyer should stand for. Ideally, the court has the power to intervene in anything. But at what point in time, to what extent? So that having seen the parameters upon which the Senate must act as a court, as a trial for this specific charge, then you must realize the limited scope of relief that one may get from the court.
Okay, and then if you look at all the grounds, we'll look at what constitutes Council Theuri shortly. But Council Harvey, where is the line in terms of the threshold question? Because here there are 11 grounds which the Senate will investigate, and the voting will be on per ground. the National Assembly did it as a wholesale vote, as a motion entirely. Here it's going to be an investigation of all the grounds. What therefore constitutes the threshold question here?
Now, the Constitution itself has said where there is belief that a serious offense has been committed. So the starting point is, if it is in respect of a serious offense, a violation of the Constitution, all that is necessary is belief. You don't need to prove it on a balance of probabilities or beyond doubt. And ideally, the threshold must resonate with what the people, the ordinary man, thinks. You, my friend, and us here, looking at the allegations as set out in the motion, and the evidence that has been tendered so far, do we have reasons to believe that they are substantiated? So that if we are to look at it from that prism, the threshold is much lower. And even if the belief is mistaken, it is a belief that is supposed to be entertained. So taken from that perspective, it doesn't matter what degree of evidence as known to lawyer is available. The issue is the belief of the senators. They may be mistaken, but they are entitled to come to the conclusion that the grounds have been established, they have been substantiated, and for that reason, we're proceeding to vote. So that if you look at it from that angle, the DP's fate is almost concluded.
Okay. Because again, we will talk about Parliament, and if we are to apply, Council the URI, all the 11 grounds that were listed in the motion of the National Assembly by Mwangi Mutuse, then that applies to the entire political establishment as well. And before we delve deeper into that, Council Harvey, in your view, what constitutes gross misconduct and violation of the Constitution?
Fortunately for us, the question of gross misconduct has been defined in the previous proceedings for impeachment that have been conducted in Senate for the governors and the subsequent challenges that went to court. The Wambora case, the Sonko case, and I think what we have is that the court has laid and the Senate has laid certain parameters as to what would constitute gross misconduct, and I think the general rule is that you would then look at the allegation in terms of violation of the Constitution and the conduct, and then apply certain parameters. Does it, for example, violate the Leadership and Integrity Code? Has it caused some level of discomfort, and has it brought dishonor to the office? Because those are some of the things that the Constitution looks at. So when the Senate will be looking at the question of either gross misconduct or gross violation of the Constitution, it would be applying that charge to the standard that they have already established, and then making a determination whether they believe that the facts as established by them in the course of hearing the case by Parliament. And we must remember that in these proceedings, Parliament is going to prosecute. So it's actually Parliament versus regarding Gachagua. So Parliament will prosecute, bring its evidence, call its witnesses, and the witnesses will be cross-examined. And the DP will also present his evidence if he has any witnesses, and there'll be cross-examination. And so on the basis of what would have come out in support and against those charges, then Parliament will be able to make an examination and a determination as to whether they believe the facts that they have established rise to the level of gross misconduct or gross violation of the Constitution.
Dr. Ojwang, in a moment shortly, when ready, we'll be getting the soundbite of the Honorable Judge Chacha Mwita, who yesterday declined not only to give the conservatory order, but also made a statement I want us to hear shortly when that's ready. But, okay, so it's ready. So let's hear what the learned judge said yesterday, besides the decline to issue the conservatory order, which was sought by the Deputy President's legal team.
It would be reluctant to question parliamentary procedures as long as they did not breach the Constitution, and that the mandate of the court is restricted to the doctrine of separation of powers, to deciding on matters of individual rights and fundamental freedom. And the court will rise to the occasion and consider whether the state organ complied with the Constitution or the law.
Council Harvey, coming to you. This was a tweet you made 5 days ago, and you said Rigathi Gachagua will cease being the Deputy President on the vote of the Senate, unlike removal of a judge which can be appealed to the Supreme Court. Impeachment of a president and the Deputy President is final and incapable of challenge. The Constitution did not contemplate judicial intervention on impeachment. In line with that, yesterday the judge was very clear, and you were there during the three-judge bench, but Chacha Mwita was clear that the court exercise supervisory jurisdiction, and that includes even the Senate, which will today sit as a quasi-judicial house. So what's your thinking? What's the rationale behind the idea that you hold that all stops for Gachagua at the Senate?
You see, the office of President and Deputy President is not a private office, it's a public office with an elaborate procedure of how one is elected to that office. Now, impeachment, in the manner in which it was designed in the Constitution, was cushioned and insulated from a judicial process. I'm not contradicting what the judge has said. The judge has elaborately put out the correct legal position. He has said Parliament, as an organ of government in the state, must act within the Constitution. But you see, the law is there to provide a remedy. Contradistinct what happens when you are summarily dismissed, you have a remedy of reinstatement. It's the first remedy. Is there such a remedy insofar as the impeachment of the president and the governor is concerned? None whatsoever. So that assuming that the Senate passes a vote on Thursday, removing the deputy president from office, and the matter is still in court, or he goes to court after the process, is it expected that the court will assume the function that is ordinarily left to the people to elect the president and the deputy president and reinstate the deputy president? I can tell you without any fear of contradiction, no order of that kind will be made.
Okay.
And that underscores the reason why perhaps the DP's legal team is persistent to ensure that they're able to countermand this process before it reaches there. Because, I mean, what used to happen in impeachments in medieval times, as soon as the French had decided that the king or the emperor is not suitable, what followed within a second was execution. You get it. There was already a king in waiting. So this is a civilized way of doing the same thing that was done in medieval time. There will be no recourse to the judicial process. Quite unfortunate, but that is how it was intended to be.
Okay.
Speedy.
Council Harvey, you hold the same position?
I'm assuming you're referring to me.
I mean, Council Deuri, yes.
He's my younger brother, so I can call him in a second.
You know that is a closely held secret, so I was wondering how you knew about our...
Yeah.
But anyway, let me say that I agree with what President Harvey has said. But there are also other very interesting scenarios that we must look at, and let me mention this. In the first instance, when we look at the way the Constitution is crafted on impeachment, it seems to envision two different routes.
Okay.
The first route is you can be removed from office for having committed a crime. Now, if you go to if you look at the American model, it focuses removal purely on commission of crimes. And so we are looking at a bad actor, a bad president or a bad deputy president who has committed crimes and so therefore should be removed from office. The second angle, and the way the Constitution is crafted, is that it looks at the question of governance.
Yeah.
It looks at the question of ethics, and it looks at the question of upholding the Constitution. And that is not a criminal standard. And that's why you have violation of the Constitution and gross misconduct. So there are two different tracks in terms of the impeachment process that have been combined into one. When you view the American model, the Chief Justice actually sits in Senate.
Precise.
Although his role is largely ceremonial, but he sits in Senate because it is almost a trial based on a criminal indictment. You know, Bill Clinton, there was an independent office which investigated Trump. There was the Mueller investigation. And if you go close to South Africa, Jacob Zuma had to be removed because of the investigations that had been done by the public protector. So you see that it is on the side of removal on the basis of commission of crimes, it is based on some sort of investigation by somebody else that establishes certain criminal acts that then leads to an impeachment. On the other hand, we are now saying that there is a removal on the basis of failure of governance, which is now the political question that is served by the process of impeachment. In our case, my suspicion is that Senate may not find good ground to proceed on the basis of criminal acts. But they may find good grounds to proceed on the aspect of the political issue. And now what the court was basically saying is that when it then proceeds in that manner, it is quasi-judicial, and it is and so therefore the court under Article 165 can therefore examine whether Senate proceeded on the basis as defined in the Constitution. But the other thing, and that's why I'm saying I agree with President Harvey, is that we must remember that then removal deals with a political problem. And that is why in the US, they have said, you know, once there's, although there is no prohibition in the Constitution, and in law, what you say, unless it is expressly prohibited, then you can pursue. But the idea is this, that since you want political hygiene, should the court be playing in that arena? And so the question that will be facing the court is a question of convenience and whether it actually wants to exercise itself on political doctrine questions, which ordinarily courts try to shy away from, because then they become very complicated.
Okay. So it's a watermark moment, and we'll extend this discussion when we get back from the break, Dr. Ojwang and Esther here on the broadcast, because there are some who hold a different view, and we'll be looking at their sampled feedback here on the broadcast regarding what will happen next, because the Deputy President legal team have shown all the hallbacks of moving to court in the aftermath of what will transpire at the Senate on Thursday. And you're watching Daybreak. Thanks for staying with us. The hashtag on X is Citizen Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir. We are back with more after the break. Stay tuned.